Thanks for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today, we're talking about accountants and discipline. Cases that should have gone to the Supreme Court of Canada, but didn't. Daniel Clark was an accountant facing discipline on the basis of, something bad that he did that's completely not relevant. What is relevant is that the person who was appointed to give independent legal advice to the tribunal overseeing his disciplinary action had previously acted in prosecutions against accountants before the tribunal. Mr. Clark successfully argued that there had been a conflict of interest and that it was incumbent on the lawyer acting for the tribunal to disclose that she had also previously acted prosecuting people before the tribunal, that it essentially created an apprehension of bias against him because she was somebody who would have been trying to get him in trouble in the past. This case is very interesting, and the Supreme Court of Canada should have taken the opportunity to hear it because it deals specifically with issues of tribunals getting legal advice. And as we move in Canada towards more tribunals dealing with more issues, the more legal advice that tribunals are going to get becomes important. And particularly here, for people in British Columbia, a lot of tribunals get legal advice from the same people that represent those tribunals in court, or from people who have previously represented those tribunals in court. Lawyers, too, move from positions in government to various other positions in government and take on different roles. And the reason that becomes important is that if you have somebody who's previously been acting adversarial and then is supposed to be giving legal advice to a tribunal, it makes it very difficult to perceive that you have a fair hearing. The problem lies in the fact that in Canada, it's very difficult to find out even if a tribunal is getting legal advice, and then when they're getting legal advice, who they're getting it from. The Supreme Court of Canada had the opportunity here to open the door a little bit on the privilege of legal advice to ensure that advice given to tribunals is fair and to ensure that those giving advice to tribunals are not people who might be in a position of a conflict of interest, as in Mr. Clark's case. This was an opportunity to create a better tribunal system across this country and to make a better tribunal system for everybody so that we can have confidence that the legal advice given to tribunals is given by people who are not in a position of conflict. Unfortunately, it's going to take another case and hopefully another good set of facts for the Supreme Court of Canada to see the important issue here and to allow an opportunity to clarify who can give advice to tribunals and in what circumstances there is a conflict of interest. You're watching Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Thanks for tuning in to Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law Corporation, and thank you to Brazen Bull Creative for putting together these videos. Please like, subscribe, share with your friends, and tune in next week.